Good day. Welcome once again to the Basic Philippine Law and Jurisprudence channel. This is the continuation of lectures on the series of lectures of Persons and Family Relations Law. Our topic for today is adoption. As you all know, the domestic adoption under Philippine laws is now governed by Republic Act number 11642, vesting jurisdiction over adoption cases to the National Authority for Child Care or the NACC. Okay, so it is no longer the regional trial courts, the family courts, which have original and exclusive jurisdiction over adoption cases, alternative child care, adult adoption, foster care, adoptions under the Simulated Birth Rectification Act, and Intercountry Adoption Act. Okay, so all of these cases are now under the original and exclusive jurisdiction of the National Authority for Child Care or the NACC. Okay, now who are the persons who are qualified to adopt? Okay, the law states that you have to a Filipino citizen at least 25 years old. You must be in possession of your full civil capacity and legal rights. You must not have been convicted of any crime involving moral turpitude. You must be of good moral character. You must be emotionally and psychologically capable of caring for children. You must be at least 16 years older than the adoptee, except when the adopter is the biological parent of the adoptee or the spouse of the adoptee's parent. The legal guardian with respect to the ward after the termination of guardianship and clearance of accountabilities, the foster parent with respect to the foster child, Philippine government officials and employees deployed or stationed abroad, provided that they are able to bring the child with them. And last, foreign nationals who are permanent or habitual residents of the Philippines and possessing the same qualifications as Filipinos prior to the filing of the petition, provided that they came from a country with diplomatic relations with the Philippines and the laws of the adopter's country recognizes certificate of adoption as valid, acknowledge the child as the legal child of the adopters, and allow entry of the child in the country as an adopter. Okay, so you must be a permanent or habitual resident of the Philippines for at least 5 years. Okay. However, there are certain cases wherein foreign nationals, even though they have not yet met the residency requirement, can still adopt because the laws waived the residency requirements. Who are those people who are still qualified to adopt despite the absence of the required residency for a period of at least 5 years? Former Filipino citizens habitually residing in the Philippines who is adopting a relative by consanguinity or affinity within the fourth degree. So if you're a former Filipino citizen, you wanted to adopt your relative, okay, provided that it is within the fourth degree, okay, you are qualified even though the 5 year residency requirement has not been met. One who seeks to adopt the legitimate child of the Filipino spouse, one who is married to a Filipino citizen and seeks to adopt jointly with the spouse, a relative by consanguinity or affinity within the fourth degree of the Filipino spouse. Okay, because the law recognizes that adoption should be joint because the purpose of the adoption is to give the child a family who would rear and care for him or for her. Okay. Now, what as a general rule, it is required that the spouses must adopt jointly, but there are exceptions to that rule. What are those exceptions? First, if one spouse seeks to adopt the legitimate child of the other, okay, so in that case, the spouse should only be the one to adopt because he is already the legitimate child of the other spouse. If one spouse seeks to adopt his own illegitimate child, provided that the other spouse gave consent. So, in order to elevate the status of the illegitimate child to illegitimate child, okay, and if the spouses are legally separated from each other, in which case, even if not both spouses are adopting, the adoption may be given due course. Okay. As I've said, the general rule is the spouses should adopt jointly. Okay, except in the following cases which we have already discussed. How about adoption by a guardian? Adoption by a guardian is allowed after the termination of guardianship and clearance of his financial accountabilities. A petition for adoption and a petition for change of name are two special proceedings. These two proceedings involve disparate issues. So in a petition for adoption, the court is called upon to evaluate the adopter's fitness and qualifications to bring up and educate the adoptee properly. In a petition for change of name, no family relations are created or affected, for what is looked into is the propriety and reasonableness of the grounds supporting the change of name. But under the rules now, considering the change in the original and exclusive jurisdiction over adoption cases, it would appear that a petition for adoption now must be filed with the NACC. However, the change of name of the adoptee must be filed with the regular court because the NACC is bereft jurisdiction with respect to the change of name of the proposed adopt. Who may be adopted? Okay, any child who has been issued. So tapos na tayo sa the persons who are qualified to adopt. Now, who are the persons who can be the subject of adoption? A child who has been issued a certification declaring the child as legally available for adoption, or the CD-CLAA. The legitimate child of one spouse by the other spouse. An illegitimate child by a qualified adopter to improve the status of legitimacy. A Filipino of legal age if prior to the adoption said person has been consistently considered and treated by the adopter as his child for a period of at least 3 years. A foster child, a child whose adoption has been previously rescinded, and a child whose biological or adoptive parents has died, provided that no proceeding shall be initiated within 6 months from the time of death of said parents, and a relative of the adopter. Okay, so these people are eligible to become adoptees. Let us now go to the cases. Petition for adoption of John Aurel Bulayo. So in this case, RA number 8552, at that time the Domestic Adoption Act, intended to include John Aurel, the biological child of Mary Jane, in the term relative, because he was her relative within the first civil degree. It is relevant to note that the OSG joins the petitioner's position and emphasizes that if the law exempts the alien adopter from residency and certification requirements, if he will adopt the brother or sister, nephew, niece, or cousin of his Filipino spouse who are within the fourth degree of consanguinity, then there is no reason to exclude the application of the said exemption if the adoptee is the illegitimate child of said Filipino spouse. Because there is an exemption, di ba, of the or waiver of the residency requirement of 5 years. Okay, if the person to be adopted is a relative within the fourth degree of the spouse, of the Filipino spouse. So in this case, what is being sought to be adopted is the illegitimate child of the Filipino spouse. So that is covered within the requirement. Why? Because they are related within the first degree. Section 7BI3 clearly covered both legitimate and illegitimate relatives as long as they were within the fourth civil degree of consanguinity or affinity. Okay? Can a brother, an elder sister, adopt a younger brother? So that question was answered in Villa versus Republic. An elder sister may adopt a younger brother. There is no law that prohibits relatives by blood or by affinity from adopting one another. Adoption statutes being humane and salutary and designed to provide homes, care, and education for unfortunate children should be construed so as to encourage the adoption of such children by a person who can properly rear and educate them. The relationship established by adoption is limited to the adopting parents and does not extend to other relatives, except as expressly provided by law. Okay? Consent to adoption. Who are required to give consent to adoption? The affidavit of consent of the following persons is required to a petition, to be attached to a petition for adoption. The adoptee, if 10 years of age or over. The biological parents of the child, if known, or the legal guardian or the proper government instrumentality which has custody of the child. Okay, except in a case of Filipino of legal age. If prior to adoption, he has been consistently treated by the adopters as their own child for at least 3 years. The legitimate and adopted children, 10 years of age or over, of the adopters. The illegitimate children, 10 years of age or over, of the adopter, if living with the said adopter, or over whom the adopters exercise parental authority, and the latter spouse, if any. You must remember that the consent of these people, the children, whether legitimate or illegitimate, if they are living with the adopter, is required because the adoptee would be living with them inside the family dwelling and would be treated as if it will be treated as the child of the adopted. Okay, the spouse, if any of the persons adopting or to adopted. Okay. The biological parents should be counseled to prevent them from making hurried decisions caused by strain or anxiety to give up the child. So all measures must be taken to strengthen the family and promote their best welfare or interest. Okay, we have the case of Castro versus Gregorio. For Jose to be eligible to adopt Jed and Regina, Rosario must first signify her consent to the adoption. Jose, however, did not validly obtain Rosario's consent. Since her consent was not obtained, Jose was ineligible to adopt. Okay, so we have here a case of strange spouses, meaning they are separated de facto. The marriage vinculum still subsists. There was no decree of legal separation or annulment. So the wife's consent was not obtained prior to the adoption. So the consent of the adopter's other children is necessary as it ensures harmony among the prospective siblings. It also sufficiently puts the other children on notice that they will have to share their parents' love and care, as well as their future legitimes with another person. It is undisputed that Joanne was Jose and Rosario's legitimate child and that she was over 10 years old at the time of the adoption proceedings. Her written consent was necessary for the adoption to be valid. To circumvent this requirement, Jose manifested that he and Rosario were childless, thereby preventing Joan from being notified of the proceedings. As her written consent was not obtained, the adoption was not valid. Okay. Now, where do you file the petition for adoption? Where do you file an application for the issuance of a child and home study report? Okay. The adoption petition shall be filed with the Regional Alternative Child Care Office, the RACO, of the city or municipality where the prospective adopting parents reside. Now, the child and home study report will be prepared by the social worker, the municipal or city social welfare officer, or any child placing or child caring agency. Okay, now the case study shall establish the true identity of the child, the registered name of the proposed adoptee, his genuine intention, and that the adoption is for the best interest of the child. There will also be a supervised trial custody for a period of at least 6 months. Within the said period, the adoptee and the adopter, okay, are expected to adjust psychologically and emotionally to each other and establish a bonding relationship. Okay, now if there is successful supervised trial custody and the NACC is convinced that the adoption would redound to the best interest of the adopt, it shall issue an order of adoption, okay, which is a registrable civil registry document stating the name by which the child is to be known. What is the effect of adoption? As we have discussed earlier, the parental authority of the biological parents will cease and will now be transferred to the adopters. All legal ties between the biological parents and the adoptee shall be severed, and the same shall be vested on the adopters. The adoptee shall be considered as the legitimate child of the adopters, and the adopters and the adoptee shall have reciprocal rights of succession. Okay, can you rescind the adoption? Rescission of adoption was also vested, okay, to the NACC upon petition of the adopter, or if on the following grounds committed by the adopters: repeated physical and verbal maltreatment by the adopters despite having undergone counseling, attempt on the life of the adopt, sexual abuse or violence, and abandonment and failure to comply with parental obligations. The venue of the petition shall be again the RACO or of the where the adoptee resides. Okay, what is the effect of rescission of adoption? The legal custody of the NACC shall be restored. If the adoptee is still a minor or incapacitated, the reciprocal rights and obligations of the adopters and adoptee to each other shall be extinguished. The NACC shall order the registrar to cancel the amended certificate of birth and restore his original birth certificate. Succession rights shall revert to its status prior to the adoption. Okay, we now go to inter-country adoption under Republic Act 1843. What is inter-country adoption? It is the process of adopting a Filipino child by a foreigner or a Filipino citizen permanently residing abroad, where the petition is filed. The supervised trial custody is undertaken and the decree of adoption is issued outside the Philippines. Now, who may adopt? As we have discussed earlier, inter-country adoption is also under the original and exclusive jurisdiction of the National Authority for Alternative Child Care. Okay, who may adopt under RA 8043? An alien or a Filipino citizen permanently residing abroad. Okay, the requirements are as follows. He must be at least 27 years old and at least 16 years older than the child to be adopted. If married, his spouse must jointly file for the adoption. He has the capacity to act and assume all the rights and responsibilities of parental authority under his national laws and has undergone the appropriate counseling. He has not been convicted of a crime involving moral turpitude. He is eligible to adopt under his national law, and he is in a position to provide proper care and support to give the necessary moral values and example to his children, including the child to be adopted. He agrees to uphold the basic rights of the child as embodied under the Philippine laws, the UN Convention, and to abide by the rules to implement the provisions of this act. And he came from a country with whom the Philippines has diplomatic relations and whose government maintains a similarly authorized agency, and that adoption is allowed under his national laws. He possesses all the qualifications and none of the disqualifications in other applicable Philippine laws. Okay. In inter-country adoption, there is this family matching. No child shall be matched to a foreign adoptive family unless it is satisfactorily shown that the child cannot be adopted locally. Okay, so it is only when local adoption is not feasible that inter-country adoption can be resorted to. RA 8043 applies to cases where the adopters are aliens who are not residents of the Philippines and former Filipinos who are permanently residing abroad. Okay. So we have the case of Spouses Park versus Liwana. So in this case, the adopters are both American citizens and they have been residing in the Philippines since 2007. Okay, and are thus living in the Philippines for at least 3 years prior to the filing of the petition for adoption. So this court finds that the petition for adoption was filed under the Domestic Adoption Act. It was properly filed. The trial court for the determination of whether petitioners are indeed qualified to adopt the child instead of inappropriately referring the adoption case to the ICAP. Settled is the rule that in adoption proceedings, the welfare of the child is of paramount interest. Of course, now it is the requirement for residency is 5 years under the Republic Act 11642. At that time, it was only 3 years. Okay, so in this case, the court said that the residency requirement has been complied with by the spouses part. So they will not be under the jurisdiction of the ICAB, but it is the Domestic Adoption Act, which was enforced at that time, that will be applied. Okay, so that is it for today's lecture. Thank you for listening and don't forget to subscribe.